Right, a bit of housekeeping, please. This is advocacy number 4, and I've got no funny face on. Well, you may think it's a funny face, nevertheless. Now, I'd like to do a bit of housekeeping in relation to what I've said earlier. Firstly, the probation in the Ivor Swag bail application. Of course, probation is what I use because I'm old. Community rehabilitation order or any supervisory previous conviction would do for the illustration. And of course, this is advocacy. It does not talk about sentencing. All right, so let's turn to Ina Boggins. Boggins, the other shoplifter, the 84-year-old. I left that with a suggestion. Perhaps the best way of doing that was really saying really nothing by way of advocacy and just let the court come to an obvious conclusion. But then I thought I'd better just revisit a bit of that, because when I sort of drafted the idea of this particular illustration, I included the fact that she did the shoplifting. She put things in her basket, but she also picked up other things which she put in her bag, which she went to the till. She didn't pay for. She knew what she was doing was wrong. She couldn't help it. She didn't know why she did it, and she was upset thinking about her problems at home, domestic issues. Right, not strictly advocacy, but I think you need to think about that. In that illustration, the reason I included that little bit in there, I think you need to spend a bit of time dealing with the issue of dishonesty there. You know, what do you mean she didn't intend to do it? What's it? And she don't know why she did it. Are we dealing with compulsion? Is there an altered state of mind in that? Is there a kind of psychological, pathological reason why she was shoplifting? This lady hadn't done it before. It might have been stronger if there had been previous convictions of a similar nature, but she said, I don't know why I did it. I felt a kind of compulsion. Now I better slow down the conversation. I'm talking a bit quickly here, which is another illustration of advocacy, because it doesn't pay to rush what you have to say. It becomes garbled to the listener. So there's a good illustration of me getting it wrong. All right, and then with turning back to her again, how would you deal with this? Well, I think I would start with the facts of the case and say, what's actually happened. I would then say that she's, I'd deal with her domestic situation, and because the explanation of worry goes very much into her domestic situation, married and so on. And then I would, I'd spend, because it is important, I think, that this lady, she's 85, she's been worrying, not sleeping. I think that's where I'd try and conclude before I get submissions of a discharge. And I think if you wanted to do a Rolls-Royce job, you could have had a letter from the GP if she'd been to see them. In fact, I would have advised her in interview to have seen the GP because she's not sleeping. That's a bad thing to happen, and that would enhance it. And of course, any character references on a guilty plea. So you could look at it like that. Obviously, the items are recovered in a saleable condition. Right. Now, advocacy generally. Trying to make this simple for me to transmit what I'm trying to say, because this is a bit of a ramble. I like to think of an analogy, which I've said in the past, that imagine you approach a court case with an empty shopping basket, and the object is to do the case, fill the shopping basket with all the goodies you've got, and then you produce it at the end before the court. It's your closing speech, basically. You're producing your shopping that you've done at the till. And that's a good analogy. So what goes into the basket? Well, I'm going to suggest that what goes into the basket is all the positive points that you're going to make in your closing speech. And first of all, the way I would think I would look at, first of all, I'd see what the prosecution case gives me. So there might well be some goodies in the prosecution bag already, which you can slip into the defence basket. So let's take an example. Say it was a guilty plea in the shopping bag, or it's relevant to a trial, that he gave himself up, that he recovered property, that he cooperated, um, anything which might help the your defence case, put in the shopping basket. Um, if you're going to say the case is unplanned, unsophisticated, have the reasoning behind it at your fingertips. And this is some things that I would run past the prosecution, whether they're going to take the issue about anything that you're going to say. Remember, of course, the judge can always have a trial of disputed facts, even in a guilty plea. So you really need to make sure firmly what the facts are going to be and what's in dispute and what isn't. And also, again, in the context of the shopping basket, let's just take a general guilty plea: family support, health conditions, domestic situations, social aspects, education. In case of a trial, of course, it could be identification. The police officer may have said it was wet and rainy and dark. All that is stuff that you don't need to cross-examine on. It can go in and you can go into the shopping basket. You've got it in the bag already. The prosecution will not be disputing that. So a shopping basket is different from a checklist. Now let me contrast the two. The shopping basket is something you're doing towards the end of the trial that you're going to produce as a goodie bag. The checklist is something that you need during the course of the trial to make sure you don't forget anything. If you're prosecuting, you want to get all the ingredients in. If you're defending, you want to draw out or if you're proving a defence or so, if you have to establish a prima facie defence or whatever it may be, have a checklist of what it is you need to achieve so you don't forget anything. Let's think of a simple drink driving case. Failing to produce evidence of the test, an oversight, unforgivable in a case like that, but it can happen. So a checklist is important. So, for instance, the shopping bag will be also filled as you go along with the trial. So some things can go in already, like references. They can go in the shopping bag, and if there's any documentary evidence which is difficult to read, it's self-evident if it's in a foreign language. But have a typed copy so people don't skip it or don't give it the weight a document's worth if it's handwritten. Consider typing it up. And as I say, so with the checklist, then I've covered that. It's the points you need to achieve. These are also points in terms of each witness, what you want to put to each witness. Remember, you have to put your case. I don't like really the end. A lot of lawyers do it, I think, where they come to the end, the last few questions, they're cross-examining and they've got to put their case. So they simply say in one bit, a blanket statement: I put it to you, officer, that this is all wrong, you're making it all up, or you're lying, or whatever the case may be, and that in fact you didn't see what you did see, and so on like that. We say you saw, and the witness will go, nope, because that's obviously what the answer is going to be. I don't think that's good advocacy. I think basically just reinforcing the fact that the person don't agree with your submission. So put your case during the course of the cross-examination, I would suggest. Or the examination chief, make sure you get everything in. Right. In terms of general rambling again, I think you need to make it where it's possible, and you'll certainly, if you're a local court, you'll pick up the characters and the histories of the various lay magistrates or district judge or circuit judges in a Crown Court. You'll get to learn what their pet hates and likes and dislikes are. Let's see if I can think of an illustration about that. Yeah, there was two illustrations. One was a circuit judge who, well, this decades and decades and decades ago, he he used to have a thing about the army. He came from a military background. He was very impressed by people that are doing military history. These chimes, by the way, you hear are chimes for various electronic devices around the house, burglar alarms and such like. So hopefully the door doesn't ring and I don't have to nip off. But if I do nip off, I'll just say I'm nipping off, and then I'll nip off. And so, okay, so anyway, so if you were defending a client, and I mean, it was almost like if your client was pleading guilty and he had any remote aspiration of joining the military, or if he had a family history, almost going back to the Battle of Waterloo, it might be worthy of comment in that particular front judge. So, for example, my client feels particularly bad, and the circumstances have let down his family so badly with their military record and public service. I mean, his grandfather, great-great-grandfather, fought the Battle of Waterloo. I mean, I'm just throwing that in. I mean, pretty unrealistic, but there, it illustrates the point. Or you could say that he is considering joining the Territorial Army to improve his skills, or whatever he says to you. The important point, of course, is not to pervert the course of justice. You've got to be careful with how you ask questions. Anyway, there was another one, lay magistrate, that was self-made, self-educated, and he used to sit in the youth court a lot, and if you're dealing with the youngsters had educational issues that were part of his character or his history, you were bound to get an interest from that particular magistrate if you approached the fact of education and your client's issues with it. So it's that kind of thing becomes important. It's not crucial, but it's a relevant plus point you need to know. And then stress. Now the government, when we got delays, and the politicians, they talk about the victims having to wait, they talk about unfair on the witnesses, but they never in fact I can't remember them ever saying, and of course the defendants stress. And let's be honest, I mean, just the fact that you've been charged in offence doesn't make you guilty of it. And, I remember, and a lot of us older advocates remember waiting years and years for trials. I mean, 4 or 5 years for a trial from the date of charging. I mean, imagine the toll that stress took. And now, of course, we're going slowly back to those days. They'll blame the pandemic on it, of course, but that's what politicians do. But it's you may feel that it's underfunding for a long time. That might well have a impact, a more greater impact in the delay. Similar with the NHS, talk about the pandemic, but then again we've been cutting funding to the NHS for years. So you've always got to listen to what the government say. I'm afraid, I'm not going to mention integrity, but I'll let you draw your own conclusions. All right. So when you are with a defendant and they are looking or feeling anxious, you've got to explore that for 2 reasons. One is it may well be relevant to your case, giving evidence as well. But also, you're a healthier client. So I would take that into consideration, and do remember advocacy is often required. Well, it's beefing up what you're saying, and so if there's a medical report from the GP, just simply say that he's been consulted by your client and he's prescribing medication for stress, and they've prescribed not being able to sleep. That's all important. Particularly if there's a suicide risk in the case. If somebody's charged with a kind of reprehensible in the public view offence, you might well um, put suicidal thoughts in their minds. You've got to be careful about this sort of thing, though, because remember the court do have a power to refuse bail on the basis of one's own safety. So be careful what you say there. Um, Now, I'd like to go back to the courtroom again very briefly and talk about the geography. Um, Obviously, um, your client is part of the overall advocacy when you're standing facing the court and your client's standing behind you. And I mentioned the fact earlier on, didn't I, about his behaviour and can undermine what you're saying. So you need to make sure that your client understands what it is you're saying and what you're expecting him to be. In the same manner, you may suggest how they dress for court. Um, I'm not sure what the political correctness is about that nowadays. But anyway, you will know the kind of case when you perhaps need to refer to it. Um, but also your client outside court, is important. I remember sitting in an ASBO case where the end of the day came and ASBOs were about to be made in this particular one individual, and he left the court. The national press were outside the court, and they were filming him as he left the court. And of course, out he came with bravado, fingers towards the camera, and jeering. And of course, the next morning in court, his solicitor, or I can't remember, his advocate, was addressing the court completely unaware that his client was behaving in the way he did. So when he was talking about things about being contrite and changing his client changing his character, of course, one had to point out to his advocate what was demonstrated by his client on the television the night before. I mean, clearly, I suspect in the circumstances of that, you may wish to accede to an adjournment request for a couple of hours while he goes and has a look at it for himself or discusses it. But anyway, it's a pretty embarrassing situation to find yourself in. So, I'm not going to talk about criminal procedures rules or current law. I'd love to, I love the law of evidence, but I've been out of the loop for so long now, and I don't have access to, as I said earlier, the periodicals and the law that I would need in order to discuss the law of evidence and criminal procedure rules or civil procedure rules of that nature. I mean, I do know because I include amongst my friends people that lecture on evidence for the bar, and there are people far more well equipped to deal with that the more in-depth analysis of advocacy and law together and the rules of evidence. But I would say this: it does pay to be closely involved with the evidential chapters in your Archbold or other such textbook as you now favour. I mean, I used to know when I was an advocate the relevant parts, the relevant chapters of Archbold, and I do think also in terms of advocacy, there are some things that you'd need to have with you at your fingertips. I mean, for instance, I remember defending a lot of alleged gang cases, and of course people would change evidence and there'd be. I mean, I actually knew all about hostile witnesses because it used to arise. Contempt of court is another thing you need to have cast your eye off at the back of the to put it in a little a little book if you however you keep it, but it's a little knowledge of the contempt of court rules. Bail Act, of course, sentencing guidelines, in the things which turn up pretty often, general legal issues. Just have a small crib sheet so you can find matters easily. But above all, I think in advocacy, if you need time, ask for it. But give reasons, of course. because it is a discretion for the court. The next thing is to discuss the order of the way a trial goes. You need to know who opens the case, the introductions of the individuals involved in the court, and the roles of the people in the courtroom. Now, I'm not going to deal with that because I suspect that is so blatantly obvious. You'd have done that on your courses in any case, and also it saves me having to look it up and refresh my memory. Right, so I think that at this point I'll pause for chat number 4, because I don't want to do them in very long sections because it gets tedious. And so, well, that's an interesting thing too. Do watch your audience in a courtroom, you know, and your witnesses. You know, people get tired, people need breaks, people need comfort breaks. You may need a comfort break. I mean, make sure you know how to ask for that and when it's appropriate to probably approach it and how to approach it. If people are getting bored too, do change the tone of your voice or wake them up somehow, or take a break if it's a very hot afternoon. Even discussing the possibility it may well break the monotony and give people a revival. These are things which I'm hoping may not be in textbooks, but anyway, these are things that occur to me as I go. So we'll deal with a bit more in the next episode, and see how much I can remember. Let's put it like that. Okay.